Now, as far as please bear with me since I'm also having to look at the heads while answering. I will have to page as well. In reply to Advocate Hodis, firstly with regards to paragraph 5, with regards to what is termed to be, I quote, the viral footage, and then thereafter the recorded footage detailed by employees of Gearhouse, the Gearhouse footage. It stated in paragraph 5 that the Gearhouse footage did not depict the shooting. However, it was cured by the evidence of the Gearhouse witnesses who testified in court that they saw it afterwards but not during the event. With regards to the submissions, that is paragraph 7, 7.1, 7.2, 7.3, 7.4, that just for everyone's clarity refers to no eyewitnesses that complained, that no eyewitnesses to the celebration had complained of any fear or danger, no eyewitnesses that come forward or had run for cover, declaring that they were in fear of their life or property, and that not one attendee from the many people who had attended the celebration was called to testify as an eyewitness. Those are indeed factors which may be relevant at some point in time. At this stage, none of these factors listed in 7 up to 7.4 are requirements for the charges that you are facing, Mr. Malema. It's not a requirement, it does not form part of the elements. In addition, with regards to 7.5, it is where Advocate Hodis raises the 5 SAPS VIP Protection Services members. On that issue, the state has a lot to say, but it is not the appropriate time to do so. I will emphasize that indeed in the heads it's correctly stated that indeed Colonel Swartboy was only confronted with this aspect during cross-examination by Advocate Hodis, and in fairness he cannot answer to the contents of those statements deposed by the 3 persons in Gauteng. Those statements were not obtained by him, it was obtained by then Brigadier, now General Govender. I'm not going to even tread on the path of the further question or statement posed by Advocate Matthews that whether he was aware that Minister Bheki Cele had to report the progress to Mr. Malema. That was not within his knowledge. Furthermore, these 5 witnesses is not evidence before court. The contents of their statements, merely to say they stated they did not witness a shooting, does not give me a full picture of what took place as to where they were. Only they could tell, and why they were not called, I find myself wondering since the day I heard so. I notice in 7.6 that they have indeed been traced as pointed out by Advocate Hodis. Now with regards to 7.7, the place where the cartridge had been found would have been underneath structures, that had been there at the time of the celebration, and stated it impossible for it to have been fired from a firearm during the celebration unless they had penetrated and damaged, and they had not. Indeed so. However, the state did not allege during the state's case that the place or the spot where the cartridge was picked up was in fact the exact spot where the cartridge was ejected. Therefore, exactly as it states in 7.8, it was not possible to say when the spent cartridge had been placed there, meaning, or found its place to the spot where it was found. (7.9) It's not possible for the spent cartridge to have been ejected from a firearm on the stage at the celebration and land where it was found. The state never alleged during its evidence that it landed on the place where it was found. I think it was all in agreement that it had a range of 1.5 and 2.5 meters to the right and to the back. To add to that, the specific request was also to fire up into the air. 7.10, there was no DNA or fingerprints attached to accused one. That is indeed so. I would have been surprised if there was in fact fingerprints or DNA after some time. With regards to the paragraph 8 and the evidence of Colonel Swartboy, as explained, there are indeed aspects that is concerning. He indeed gave a precise recount of his investigation during the matter. However, during cross-examination by Advocate Hodes, and he stated, I accept, clarification was not sought by the state, and I cannot draw, I don't know what he in fact accepted during his cross-examination. However, it does not take away the evidence that is placed on record by him at this point. I've dealt with the VIP close protection units and as far as it relates to his evidence already. With regards to 8.4 and the creation of the reconstruction and Sergeant Becker's evidence, as well as the CD made from the viral footage, the court had dealt with that aspect by placing the evidence presented by court on record up to that stage. So I think I have replied to those paragraphs. The fact that accused 2, as mentioned in Advocate Hodes' application, that accused 2 fully cooperated and assisted throughout the process. Rifles were received in 3 batches. That is indeed the case. I have also dealt with that during the evidence that was placed on record so far as presented to court. I do concede that under paragraph 9.4, Colonel Swartboy had indeed confirmed that he had seen the statements by the 5 close protectors, but the contents thereof is still not before court. He confirmed had they seen a crime being committed, they were duty bound to report it. We are again 9495 deals with the DNA and fingerprints. I have already addressed that issue. That includes the powder residue tests, which were negative. And then 9.8 refers to no one complained about the conduct at the celebration, no eyewitnesses. I have replied to that. It is indeed so that the photographer of the viral footage was confirmed he had not traced the source, and that the chain of custody then only began when the CD was created. What 9.14, the item that he had referred to as being what appeared to be a firearm could not be identified through enhancement and still photos. That is indeed the position. However, keeping in mind that the evidence and the cross-examination with regards to accused one and the firing and the muzzle flash, etc., was that you had indeed fired what was called a movie or TV firearm, which also creates a muzzle flash. I keep that in mind. Accordingly also, Colonel Swartboy could not deny that a stage gun or a blank gun may emit muzzle flash. .3 I have answered to by referring to the evidence led, that is that accused number 1 is alleged to have fired a .223 Norinco firearm. So to state that the state had not led any evidence in that regard is not correct. The same accounts for 10.4 and 10.5, and most certainly the court agrees that it is accused one is not required to give evidence to supplement the state's case. I will move on to the words of Advocate Matthews as far as it pertains to accused number 2. In this regard, accused number 2, the same applies. I will try to summarize the whole version and cross-examination as placed before all witnesses and in their heads and addressed by Advocate Matthews. It comes down to the fact that count 4 and count 6 remains a statutory offence. It was confirmed in the evidence so far presented by the state that the firearm in question, being the SPA 249/14, is indeed your firearm, or the company's firearm, if I should put it in that manner. The cartridge that was picked up at the scene or close to the stage or after the incident is linked with microscopic ballistic analysis to the SPA 249/14 firearm. Much emphasis was placed on the fact that none of the videos or witnesses testified that they saw you handing a firearm to Mr. Malema. But that is not the charge. The charge is, and I will read for clarity, it's much wider. It is to unlawfully supply or in any other manner give possession of a firearm or ammunition, being the Norinco firearm and a Remington bullet, to accused one. So the actual not seeing of handing over is not a requirement in terms of count 6. It is supplying or in any other manner give possession. Therefore, accused 1 and 2, you may stand up, please. At this stage of the proceedings, I think the court has placed the evidence so far presented by the state on record. I have in the evidence clarified the issues and heads raised. I've tried to give reasons for the decision that I am about to pronounce, and to add whether it is correct or not in respect of accused 1, a mere say-so that it was a movie gun does not make it so. It's not evidence, the mere say-so, in the light of the evidence that has been presented so far. I'm not saying which has been accepted as facts, but which has been presented so far. So in that light, accused 1 and 2, number 1 in respect of counts 1, 2, 3 and 5, accused 2 in respect of count 4 and 6, the application for discharge in terms of section 174 of Act 51 of 1977 is not granted.
If the court pleases.
You may please be seated.
Bishop, I think that is the role for this particular court. We may.
No, there's no, it's not yet. Maybe you want to run. Yes, I want to stay in open court so that we all are on the same page. The only reason that I am of the view that dates, I personally prefer to discuss it in chambers. I provide the defense with subsequent dates to also see whether it suits the schedules of accused 1 and 2, because my diary contains names and certain dates which I don't think is fair to be placed on media as to which cases and which people I will be dealing with, and I think the same accounts for the whereabouts of the defense. For that reason only, I do not want to do that on media or television or even social media. Okay. In order with that?
Yes, yes.
All right. I assume you will follow in a few minutes, 10 minutes or so after you go. Sorry?
We'll come to know.
Court will adjourn.
All right.